it's been reverting back in the wrong direction. Okay, you can be seated. I apologize. The temperature in here is a bit uncontrollable. I was just sharing last week, it was actually worse. We had someone in those walls trying to figure out what was going on. But then the temperature outside has gone back up. So it's probably impacting what's happening in here. But if anybody gets uncomfortable, you can let me know. I am not going to require you to keep your mask on if you don't want to because of the temperature in here, okay? So do it at your own level of comfort, okay? I don't want anybody having a medical emergency in the middle of the trial. With that being stated, we can proceed with opening statements.
Thank you, Aaron. Everyone deserves to feel safe in their own home. At their own home. Michaela did. And you might be wondering why she didn't feel safe. Michaela's here to tell you today why she didn't feel safe. Michaela's going to come up here. She's going to swear to tell the truth. And then she's going to tell you what happened. She's going to tell you how on that Monday morning on August 8th, the defendant showed up at her house unannounced, uninvited, earlier in the morning. She's going to tell you that when he showed up, he didn't try to call. He just knocked on the door a few times. Knocked on the door, he banged on the door for 10 minutes, screaming at her, calling her names, screaming on her, bring the kids out, screaming on her to get out of the house, all the while calling her names. She's going to tell you how that made her feel and why she didn't come to the door initially. She's going to tell you that after 10 minutes of this, she finally gave in. She finally came to the door because he just wouldn't leave. He wouldn't quit. He just kept banging on that door, calling her names and screaming at her. She's going to tell you how she opened that door to let him see their kids. And she's going to tell you how they began to argue. Or they began to verbally argue. She didn't like that, and it made her uncomfortable. And it made her feel unsafe at her own home. She's going to tell you that he didn't live there. So he didn't need to be there. She's going to tell you that she wanted to go back inside. And she decided to go back inside because of this argument and where it was headed. She's going to tell you that she went to pick up her child, to take her child back inside. But the defendant didn't want the child to go. They didn't want their daughter to go with her back inside. So he backhanded her across the face. And then when Kayla tried to reach for her child, to take him inside as a concerned parent, he shoved her out of the way. Because again, he didn't want the kids to go anywhere. And then after he shoved her out of the way and took the child, she went to call for help. And when she went inside to call for help, took their child, and he fled the scene. He left. Ladies and gentlemen, the elements of domestic violence are they had to have a child in common and that they were in a dating relationship. And the defendant committed an assault on Kayla. Kayla's testimony will tell you that that's what happened. He committed an assault. So I ask that you return her to the building. Thank you.
Ladies and gentlemen, when we first met, I talked about this being a flip of the coin. A literal he said, she said. I have no doubt Kayla's going to say that. And no doubt she may even cry as she does. The prosecutor said she may claim my client was screaming, calling her names in the neighborhood, August 8th, in the morning, warm, windows open. Only Kayla's here to talk about it. Kayla will say she was afraid for 10 minutes. For 10 minutes, she didn't call the police. Because you'll hear testimony that indeed my client did go there and announce, because that was the pattern of what they did in exchanging the kids. So my client is the father of 2 children with Caleb Smith. And for him to see his children, he has to go there, he knocks, and this has been their pattern. But even though she apparently was unsafe, she goes to the door because it is a pattern. They get an argument again. That's what she says. My client will tell you otherwise. There won't be any witnesses, no police here to tell you, confirm. My client will tell you what he told the police. He didn't hit her. He didn't shove her. He didn't touch her. In fact, he'll tell you that the police asked for pictures of his hands and showed them. Because they were afraid maybe there were marks from apparently the accusation backhand. There were no marks, no gouges, no scratches. And you'll hear testimony that a 4-year-old child wasn't grabbed, but rather was held by her father, because she hadn't seen him for several months. He held her and she held him. She was happy. In fact, you'll hear another witness talk about that moments later, after he left and went to the child's grandmother's house. The child wasn't upset. The child wasn't asking for mommy. The child wasn't terrified. Curious. Prosecutor says that Caleb Smith is going to tell you she went back inside to get help. And you'll think to yourselves, if you're really that afraid for your daughter, why would you go back inside? Why wouldn't you ask for help from the neighbors? The totality of circumstances is what you'll hear, not one side. Not just 2 people going back and forth, he said, she said, but the totality of what's lacking, of what's not there, of how the child, because apparently she was there. And I trust that when you're done, when you consider all the testimony, the totality of circumstances, in fact, there aren't other witnesses in the neighborhood that would have seen it because it was not inside the house, it was outside in open view. The child wasn't afraid. The child was okay. That there were no injuries to my client from some alleged backhanded slap. I trust you'll find that it's not just a reasonable doubt, but that he's innocent.
You can call your first witness.
Thank you, Your Honor. People call Kayla Smith.
When you get to that step, if you want to raise your right hand. Okay. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat there, ma'am. Okay, I have a microphone that's in front of you, and the person behind you is my court recorder. She has to take down everything being stated here today. Oh, so I need your responses to be loud and clear and verbal, no head nods or shakes or mm-hms and uh-hs, because we can't understand that in the record, okay? Yes, ma'am. Also, if there's an objection by either of the attorneys, you would stop your answering, and you'll wait for me to give you instructions and ask you whether or not you can give that answer, okay? Okay? Okay.
Yes.
Please state your first and last name and spell them both.
Ayla Smith, AYLA SMITH.
You can proceed, gotcha.
Thank you very much, Your Honor. Is it okay if I call you Kayla?
Yes,
Kayla, on August 8th of 2022, where were you?
I was in the comfort of my home.
Where's your home located?
Here in Lansing, Michigan,
What's the address?
1813 South Lansing.
And that you said that was in Lansing? Is that in Egan County
Yes.
in Michigan?
Yes.
Thank you. And you said that was your home, so you live there?
Yes,
Do you live there with anybody else?
just myself and my two children,
Where are your children's ages?
8 and 4.
So on that morning, what happened on that morning?
So we were just relaxing, and then I get a knock at the door. It's the father of my children. He wanted to see his children.
We have like more of a scripted, sort of narrative response, more of single question. Seems to be an open flow. as opposed to just
Well, I
single
think you guys saw what happened. She answered the question, but I think
She just paused and I was
she
getting ready to
paused
follow up
kind of
with,
naturally.
I was getting ready to follow up with my next question.
Thank you.
So when you say there was a knock at your door, was there one knock?
I want to say a few knocks. I don't really remember in particular how many knocks. It was.
And who was there?
Christian Morrell.
And why was he there?
He wanted to see his children.
And did he call you before he came?
No, there was no call prior to showing up at my door.
Did he text you before he came?
Um,
Shoot you an email?
Yeah.
So when he was knocking, about how long did he knock for?
maybe a minute or two. I can't remember specifically. Sometimes when there's a random knock at my door, I don't answer right away. I'd like to see what's going on, who's at my door first.
And you said you saw who was at your door?
Yes.
Is that person sitting in this courtroom today?
Yes.
Can you describe where they're sitting and something they're wearing, please?
He's sitting right there, in the blue suit, red mask.
Can you defend to pull down his mask so that you can see?
That's Christian.
Let the record reflect that the witness is ID, the defendant.
Any objections, identification?
None, Your Honor. We'll stipulate
Pardon?
to it.
Identification is noted.
And you say he was the father of your children? Is he,
Yeah.
is the father of both your children?
Yes.
What kind of relationship did you have with him? Do you have with him?
At this moment in time, it's obviously strained. There's a whole another case for another time, about.
Your Honor,
things we've
objection.
been through.
Objection, Mr. Rowe.
The objections to relevance, do you want to respond to the objection?
The relevance is established in the we're into a dating relationship. I was progressing through that. question- line of
Maybe we can
questioning.
ask that question a little more directly then.
Yep.
To avoid any irrelevant information.
No problem.
Objections sustained.
So had you dated the defendant
Years prior, yes.
for about how long were you dating?
I want to say maybe 4 years, if you would call it.
And how did you know that it was him at the door?
I looked through and.
And how did he look when he was at the door?
Just, I'm not sure, natural, like himself.
And was he knocking like a normal person would knock, or was it frantic?
It was, I think normal.
Was he screaming at you?
At one point in time during the visit, yes, he was.
Was he screaming while he knocked?
See a lot of this memory of, how he was interacting with me was forgotten because of the trauma that I kind of went through with the situation. So
Did you give a statement to police on this?
I did.
Would seeing a statement help refresh your recollection?
Yeah.
You know, that approach.
No, I'm gonna object. It's not necessarily, I don't believe it's, if I can see it. If I can see it. I don't believe that's a statement that she gave. It's the police report that was given. It's the narrative of the police officer. So it's not her statement that's being presented to her to refresh, but rather an officer's interpretation. If they wanted the officer here, the officer could be here to testify to his report.
Okay, she gave a statement to the police officer, which is her testimony, so the objection's overruled.
May I approach?
You may.
Just look up at me when you're done. Refresh your recollection, please. Did that refresh your recollection? And was your memory better on August 8th when you talked to the police officer?
Of
or was it better
course.
today?
Definitely, it's probably better today.
So when he showed up to your house, how long was he knocking on the door?
10 minutes.
Was it a knock as a friendly knock?
It was, I'm sure it was aggressive.
Was it shouting?
Yeah.
So after he knocked for 10 minutes, shouted, what did you do next?
I opened the door. And
Can you keep your voice up, please?
yes, I gave in and allowed him to see his children. They typically do. If you can do this, I'd like to let them sit on the porch and sleep at the top.
And what were you feeling when you knocked on the door and banged?
A little fearful, a little nervous.
So once you got outside, what happened?
Mr. Morrell decided to call me out of my name.
How are you on the porch?
I was standing at my door. I never left my house. I was happening.
Does your porch have steps up to it?
Yes,
Where was he located?
he was located near the steps. On the porch. But near the steps.
And you let your daughter out to see him?
Yes,
And was she in front of him?
yes.
And what happened after you let your daughter out to see him?
He hugged her, you know, maybe ask her how she's doing, stuff like that. All while, calling me out of my name, being upset with me for our circumstances.
What was his tone?
He, was very aggressive toward me, all the while trying to be soft to my daughter who was in his arms.
Did you begin to argue?
I tried not to indulge in the argument. No, I did not argue. I was not up for arguing.
And about how long were you out there on the porch?
I want to say anywhere between 5 and 10 minutes.
What happened toward the conclusion of that 5 to 10 minutes?
Mr. Morrell decided he wanted to put his hands on me. He slapped me across my face.
Did he slap you with his right hand or left hand?
So it was right.
Was it with an open palm?
Yeah.
In front of his hand or the back of his hand?
I want to say it was back.
In that moment, what did you feel?
Pain, hurt, disappointment that my daughter had to see that.
So what did you do after that?
I called the police.
What did you do with your children?
My oldest didn't want to come out. She stayed in the house the whole time, so she didn't have to witness that. But my youngest was still in her father's arms. So when I went in with her, well, I originally tried to take her out of his arms, but he was dodging me. So I just went in and called the authorities. When I came back out, he was gone with me. So.
Did anything happen when you tried to get her out of his arms?
Just maybe pushing, shoving off. Outside of that.
Did he push you when you tried to get your daughter out of his arms? And then you said you walked in to call somebody for help?
Yes.
After you called somebody, what did you do?
I went to look outside to see if there were anybody. I looked outside to see if he was still there, and he wasn't.
And how did you feel when you realized there was nobody there?
Hurt that my child was not at home in her safe.
And you said after he slapped you, you felt pain. Where did you feel that pain?
Across my face and in my mouth.
What was the rest of that?
Cross exam.
Morning. Or
Morning.
good afternoon. It's been a long day. So this happened on August 8th, 2022 at 9:30 in the morning. And that was a warm day, correct?
I'm sorry.
That was a warm day, correct?
Yes.
It was 9:30, kids were home from school because it was summer break, correct?
Right.
And you live in a neighborhood, correct?
Correct.
You indicated there were a few knocks, correct?
Yeah.
And at first you recalled that they were the usual knocks, correct?
Yeah.
Now you said you were traumatized
Is that a yes?
Yes.
and you have gone to counseling,
I didn't see a therapist.
but were you seeing a therapist before that?
Prior to, yes.
You indicated that when you looked at him out the window, he didn't look mad. Right? You just testified to that. Right?
Sure. Yeah.
You said that when you opened the door, your daughter was up, correct?
Yes.
And she ran to her father, correct?
She went outside.
And Miss Morrell picked her up with his right hand.
I'm not sure what hand he picked her up with,
But he was holding
but
her
he was
with
holding her
both
with
hands
arms, yes.
the entire time.
Yeah, obviously, he had to let her go in one way or the other, but yeah.
You don't recall seeing him let her go, correct? You said obviously, but you don't recall seeing him let her go, correct?
That's my memory.
On that day, you had a nose piercing? And you had those piercings in? And you have a lip piercing, correct?
Yes.
And that was in as well, right? You didn't call out for help to anybody in the neighborhood, did you?
No. Just the authorities.
You just called the police.
Right.
And you went in, if I recall right, you told the police that you had gone in for maybe 5 minutes and waited before calling them, correct?
No, absolutely not. I called them right away after he put his hands up.
Nothing further, right?
Can you redirect?
No regret, Your Honor.
May this witness be excused? Thank you, Ms. Smith. You may be excused. Call your next witness.
People arrested this time, Your Honor.
Since we call any witnesses.
Yes, Your Honor.
Call your first witness.
Ms. Morrell, can you take the stand, please? If you don't mind, take the mask off when addressing the jury.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat. Counsel, did you want to coordinate him about the rights he's relinquishing at this time?
Yes. Ms. Morrell, you understand, you have a right to remain silent, correct?
Yes, sir.
And that's under the US Constitution, under the Fifth Amendment, right?
Yes, sir.
And we discussed that you could use that Fifth Amendment protection to not say anything in your defense, correct?
Yes, sir.
And no one would hold it against you.
Yes, sir.
The jury would be instructed they could not use that against you. And that you would remain innocent until proven guilty.
Yes, sir.
Do you wish to waive that right? Do you wish to take the stand and not use that right?
I'll take a stand.
And did you do so voluntarily?
Yes, sir.
Did anyone threaten you?
No, sir.
Did anyone promise you anything in doing?
No, sir.
You understand that by taking the stand that now opens the door for the prosecution to cross-examine you, correct? You can proceed, counsel.
Mr. Morrell, tell me your name.
Kristen Morrell.
And do you have children?
Yes, I do. 2 daughters.
Do you have them with Kayla Smith?
Correct.
Let me take you, and your daughters, what ages are they?
8 and 4.
Let me take you back to August 8th, 2022 at around 9:30. Do you recall that date?
Yes, I do.
What were you doing that morning?
I went to go see my daughters.
Did you call?
No, I did not.
Text?
No.
Do you usually just go unannounced?
It's like the usual thing we do, so that's what we do.
I'm sorry, can you say that
The
again?
usual, that's like the usual thing we do.
And she allows you to come.
Yes.
She allows you to sit on the porch or play with kids in that area. Right.
Yes, correct.
In the past, she's allowed you to take the kids to your parents' house. Right?
Correct.
And so it's common procedure for you to come over and
Correct.
she's never said she's had an issue with that in the past, right?
No.
When you got to Kayla's, what did you do?
I knocked on the door for about 15 to 20 minutes.
Did you knock aggressively or loudly?
No, we're not.
Did you yell during this time?
No.
How long did it feel?
Feel like 25 to 30 minutes.
Prior to that, when was the last time you'd seen your kids prior to August 8th?
A few months.
Few months?
Yes, correct.
Had you asked to come see them before?
Yes.
And she just avoided you?
That was fine.
Did she finally open the door?
Yes, after,
And when she did, how far away were you from the door?
I was by the steps, 2 feet back.
Um, Did you hit Kayla when she opened the door?
No,
Who else was at the door?
my daughter,
Which one?
my youngest daughter.
And when you saw your youngest daughter, was she happy to see you?
Yes, she was.
Did she look scared?
No.
Were you happy to see her?
Yes, I was.
And how did you show your daughter that you were happy to see her?
I took my right arm and gave her a
You just kept her in your arms?
embrace.
Did you keep her in your arms
Yes,
the entire time?
yes.
And so you said you picked her up with your right arm. Is that because you're right-handed?
Yes.
Did you leave with her at that point?
After about 5 minutes of trying to get my daughter out, she wouldn't come out, so that's when I left her.
When you say your daughter, do you mean your older daughter?
My older daughter, she wouldn't come out.
Did you yell for her to come on?
I asked her, her mom to for her to come out. She responded to me.
So you were speaking to your daughter, not to Miss Smith.
Yes,
And after a couple minutes, you left.
yes.
When you left, did you just go straight to the car?
Yeah.
You got a truck with that. And you didn't hit anybody.
Nope.
Did your daughter in your arms?
Yes.
Did your daughter go willingly?
Yes, she did.
Did anybody in the neighborhood try to stop you?
Nope.
Now, where did you go after you left?
Straight to my parents' house.
And why did you go there?
That's where I reside.
Was your mother or father there?
My mother was
How long had it been since they seen your daughters?
a few months.
Did you want your parents to see her?
Yes, correct.
Now, the police came to your house, correct?
Yes, I did.
Okay. And they wanted to ask you questions.
Yes, sir.
You understood you didn't have to answer the questions, correct?
Yep.
Okay. And did you choose to answer their questions?
Yes, sir.
Did you answer them honestly?
Yes.
Openly?
Yep.
Okay. Did they ask if you hit Kayla?
Yes, I did.
And what did you say?
I said no.
Did they ask if you could have hit Kayla accidentally?
Yes, I asked that. Yes, sir.
And what did you say?
No.
Did they ask to see your hands?
Yes, sir.
Were they paying attention to the back?
Yes.
Did you resist?
I did not.
You let them see them?
Yes, sir.
Front and back.
Right, yes, sir.
Is there any marks?
Yes, sir.
Any scratches?
Nope.
Any gouges?
Nope.
On August 8th, 2022, you told the police that you did not hit Kayla, correct?
Correct.
You said that honestly?
Honestly.
You said that truthfully?
True.
You understand that today you're on the road, correct?
Yes, sir.
And you understand that you've sworn to tell the truth to this jury and to the court.
Correct.
And you're telling this jury that you did not hit Kayla.
Did I kill him?
You did not show it.
No.
At any time.
Nope.
On August.
Is that a no? How's a no, sir?
Is that a no?
Yes, no. Yes, no.
Okay, thank you.
Nothing further, Your Honor.
Possibly.
Thank you, Your Honor. Mr. Morrell, you said that it had been a few months since August 8th, since the last time you saw your children.
Yes, sir.
How long is a few months?
About 3 months.
But you usually just come unannounced,
That's the only thing we do. Yes, sir.
but you hadn't done it in 3 months.
I've done it before that, but she wouldn't see it, so she wouldn't see it. Actually, doing my side thing.
And you knocked for 10 to 15 minutes.
About 15 to 20 minutes.
Is that normal?
Yes.
Is it normal to knock on somebody's door for 10 to 15 minutes?
For me, yes.
And you asked to see your kids,
Yes, correct.
but normally you don't ask.
I asked if she would respond with the clarification of this.
And when you left, did you tell Kayla where you were going?
No.
Was that normal practice too? You just took your kids and left?
Relevance as to the charge,
I'm sorry,
relevance as to the charge.
what's the relevance?
Relevance is they're trying to establish a pattern. This is what they do. I was just asking if this is normal.
What's the credibility?
Okay.
Rule.
Thank you, Anna. So I don't think I caught that answer.
Repeat the question.
Do you normally just take the kids, and don't tell anybody where you're going with them?
Yeah.
Let me feel you on.
I didn't hear what you said.
Sorry,
I didn't hear what you said.
you didn't hear what I said? I
Yeah.
said nothing further.
Oh, okay. Any redirect.
Quick question. Ms. Morrell, in the past, have you taken your children
Yes.
and told her where you're going?
No.
Have you brought them back?
Yes, sir.
You're their father,
Yes, sir.
blood father,
Blah, blah, yes, sir.
nothing for everyone.
Please, please stand. Thank you. Mr. Morrell, you can return to your seat. You can call your next witness.
Your Honor, at this point, we're going to call Sangria Morrell. We've got a moment.
Ask security, maybe she wants to.
She may have done it. It's on the first floor.
You can ask security. Don't know. She might.
We apologize for the delay. Your Honor, I believe she was putting it separate.
Okay. Sounds good. You come right up here, ma'am. Just raise your right hand for me. Yep, you can face me. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Think you can have a seat?
Ms. Morrell, if you don't mind, you can take your mask.
Okay, and so there's a couple of rules. There's a court recorder behind you and a microphone that's right in front of you. You have to be able to hear all of your responses, so try to keep your voice up. You have to give verbal responses, not head nods and shakes to yes or no questions, okay? Okay. And if there's an objection, you'll stop your answer so that I can rule on that objection, and then I'll tell you if you can give that response. Can you spell your first and last name for me, please?
It's Sangria Morrell.
Sangria Morrell?
Yes,
Okay, you can proceed.
State your name again.
Sangria Morrell.
And how do you know Mr. Morrell?
He's my son.
And do you have granddaughters with him?
Yes, I do.
What are they?
Sanala and Samara.
And Somalia is the 4-year-old?
Yes,
Let me take you back to August 8th, 2022. Do you remember that day?
yes, I do.
Where were you in the
Oh.
morning?
I was at home.
Did your son come with Somalia?
Pardon me?
Did your son come to your home in Somalia?
Yes, he did.
About what time?
It was after 10.
So how long had it been since you've seen Somalia?
Objection relevance.
I'll withdraw. When you saw Somalia, did she look agitated?
No,
Was she upset?
no,
Was she
Objection,
crying?
she was, no, she was upset.
no.
Well, let's stop. Here's an objection as to,
Your Honor, she can give her,
Speculation.
Your Honor, she's a witness to the child's emotions. I'm not asking her to be an expert witness, but as a mother and grandmother, she can certainly testify to whether a 4-year-old is upset.
or appeared upset, maybe.
I'll
I
be,
think she could testify as to how the child's demeanor when she arrived, so I'll overrule the objection.
thank you. So was she upset?
No,
Was she happy to see you?
yes, she was.
Was she asking for a month?
No,
Was she afraid?
no.
How long did she stay there?
At the most 45 minutes.
And then mom came and picked her up
Well, she was taken away. Yes,
to go to mom.
So yes,
Is that a yes?
yes,
And I know if she loved, in your opinion, did she enjoy being with you?
Yeah.
Did she enjoy being with her father?
yes,
And you saw her with her father?
yes, I did.
Nothing but.
Pastor Jim.
Yeah. Mr. Morrell. You love your son?
Yes, I do.
And you're here to testify on his behalf.
Yes, I
Have you talked to your son about this case prior to today?
Yes.
How many times?
I'm not sure.
Have you seen any of the police reports in this case?
Yes, I have.
How many times did you go over them?
Once, I mean, I looked at it.
Did you go over them with your son and his attorney?
Yes, I did.
Nothing further on.
Read this, please. I'm sorry, any redirect.
Ms. Morrell, did you swear to tell the truth?
Yes, I did.
Did you lie for your son after swearing to tell the truth?
No, I wouldn't.
You just tell that oath under knowing there's penalty of perjury.
Yes, I know.
And you know that you swear before the court and before any higher power that you acknowledge, correct?
Pardon me?
You swear that oath before the court and any higher power, correct?
Yes, I tell them the truth. Yes, absolutely.
That's all I need. Thank you. Nothing further.
His witness be excused.
Yes, ma'am.
Yes,
Thank you, ma'am. You may be excused.
can she remain in the courtroom?
If you have no more witness, I don't see.
No, we don't.
Okay. Uh, Any rebuttal, any rebuttal witnesses?
None, Your Honor.
Okay, you can proceed to your closing argument.
Thank you, Your Honor. Ladies and gentlemen. Kayla got up here from the stand. She told you what happened. She told you about how she felt that day. And she told you that she was smacked. She was shot. There's been no contradicting evidence to say that they didn't have a child in common or that they weren't dating at the time. So we're going to look at the elements that put them in life beyond reasonable doubt. Element 2 was that they had a child in common or a dating relationship. Kayla told you that they had a child in common, and told you they had a child in common. That element's still met. As to element 1, she did make an assault. She did make an assault on Kayla. She got up here. She told you how she was backhanded. Told you how she was shoved in the process. That's forceful and unwanted contact the defendant made against Kayla Smith. The elements have been met, and they have been met beyond reasonable doubt. And I would ask today that you come back to the verdict of guilty.
Said from the outset, when we brought you in, that the he said, she said. Just because Kayla Smith said something doesn't make it beyond a reasonable doubt. Doesn't even make it guilty. Think about what was promised to you. My client was screaming for 10 minutes. Hilleston didn't say that. My client was pounding on the door. Hilleston didn't say that. Should be corrected at some point. And you looked at Kayla Smith. Was she assertive? Was she confident in what she did not? She knew about this day. She prepared about this day with prosecutors. She read a police report. In fact, she did so right here. Don't let those things distract you. But think about the totality. These things supposedly happen, even with what she said. After she was corrected in an open neighborhood on a warm summer day in the morning, kids out of school, windows open. She doesn't go running to the neighbors for help. None of the neighbors come looking concerned. None of the neighbors call the police if they supposedly see somebody pounding, yelling, screaming names. None of that happened. Police weren't. Police didn't come and confirm anything. Even though we used their police report to refresh the memory. Police could have testified. There's reasonable doubts. Because as we look at the totality of the circumstances, as parents, do we not go running for help if we feel our child is in danger? Do we not shut the door and call the police if we feel we are in danger? The fact is, this was common because she wasn't allowing her client, Mr. Morrell, to see the kids. The interesting thing she said is, and one thing they agree on, after all this, 4-year-old comes running to her dad, jumps into his arms, he grabs her with his right hand, he grabs her, holds her off. And after not seeing that child for several months, he kept holding her. He wants to see his other daughter. She goes home. Well, went to his parents' house. Apparently they don't talk. It's okay. As Mr. Morrell testified, that's happened in the past. That's not part of the issues. There are no medical reports. There aren't any pictures. There being back end of the mouth with piercings. Back end of the mouth covers the nose, mouth, piercing. And those gouges, those scratches, go on. When you look at the totality of the circumstances and you listen to Mr. Morrell, because what did he say? I came to see my daughter and knocked. I didn't know. She finally came to the door. I stood at a distance and my daughter came running to me. I held her with both hands. I asked her how the daughter come out. She didn't. I don't think you have to worry yourself about losing doubt. My client is innocent. Christian Morrell is innocent. He's been falsely accused. But at the very least, you would have multiple reasonable doubts, and the prosecution did not meet their burden. So we ask you to come back if they're not guilty.
Yes, briefly, Your Honor, thank you. Injury is not an element. She doesn't have to have been injured to be assaulted. Having pictures here at trial is not an element. Having an officer testify is not an element of the crime. The elements of the crime are a forceful or offensive touching made against Kayla Smith by the defendant, and if they had a child in common or were in a dating relationship. how her daughter felt has nothing to do with whether Kayla was hit or not. Her daughter's 4. How her daughter's seen has nothing to do with how Kayla felt, or if Kayla was hit or not. Don't let the defense distract you with what her daughter may or not have felt. This trial isn't about her daughter. This trial isn't about what happened, may or may not have happened to her daughter. This trial was about what happened to Kayla Smith. Kayla Smith got up on that stand and she told you what happened to her. I would ask that you come back to the guilty verdict. Thank you.
Okay. Arguments have been concluded. We are going to take a brief recess, give you some time to stretch. It's not been quite an hour, but almost. This is a pretty quick presentation of the proofs. We're going to go over some final instructions, and I'm going to bring you back in here to go over those instructions before you can deliberate. So this is not your opportunity to discuss any of the testimony that you heard today. You're not free to deliberate or exchange notes at this time. I have to give you some more instructions first, but this is a time for you to stretch. I think I could use the restroom, and then we'll be back here for our final instructions. All right, for the jury. Let me put that at the bottom. Did you get that one, Mr. Gazelle? 20.25. So if you're on the, you know where to get them from, right? It's gonna be under a sex crimes, but it's a permissive instruction. I don't know why this is doing this. We don't do Mr. Bermudez. Oh, no, we're not gonna bring the jury in just yet. We're still
We
voting
were all
on it.
standing up for him.
That's an honor.
It is.
I'm sure Mr. Berman is honored, correct?
I tried that. I tried to have people stand up for me. That didn't work.
We're adding jury instruction 2.25, 20.25. Why doesn't it want to enlarge? Okay, there we go. To prove this charge is necessary. Any other additions from the prosecution? Any changes from the defense? Please call the complaining witness. This is Kayla Smith, correct?
Yes, sir.
Oh, great.
No, Your Honor, there's no change.
Okay, well, we can bring the jury in. Can we drop that door open? We need air in here. Okay, we have everybody back. You can be seated. Okay, and for our last and final instruction, if you want to fix your attention to the screen here. For some composite instructions and instructions on evidence. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence. And you must be careful not to consider them as such. The fact that the defendant is charged with the crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject anything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influence that affect how the witness testified? In general, does the witness have any special reason to tell the truth or special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Again, the elements of this charge of domestic violence. The defendant is charged with the crime of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Kayla Smith. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Kayla Smith reasonably fear an immediate battery. At the time of an assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought he had the ability. A battery is a forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Kayla Smith's will. Second, that at the time, Kayla Smith had a child in common with Christian Morrell and was a person with whom Christian Morrell had previously had a dating relationship. A dating relationship means frequent, intimate association, primarily categorized by the expectation of affectional involvement. It does not mean a casual relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 8, 2022, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all of my instructions together as the law you are to follow. Both parties have seen the jury verdict form, correct? And there's no objection?
No objection.
No. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judges, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know what or how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal to anyone outside of the jury room what your verdict is. When you go to the jury room to deliberate, you may take your notes and a copy of the full instructions. If you want to look at any of all the reference documents or exhibits, which we had none, then you would have needed to ask, but we didn't have any exhibits. When you go to the jury room, you'll be given a copy of the instructions that you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. And I have prepared a verdict form listing those possible verdicts, and they've been approved by both the prosecution and the defense. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is the evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that is circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime. He only has to show the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, and how he did it, or by any other facts and circumstances and evidence. Can you change that in the jury book? You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. To prove this charge, it is not necessary that there be evidence other than the testimony of Kayla Smith if that testimony proves beyond a reasonable doubt. And so that concludes our composite instructions, and it is time for a lucky person to be drawn from this cup. You will not have to deliberate if your number is drawn. Ms. Nash, phone number for me. Okay, juror number 7, thank you for your service today, and you are free to go. And the remaining jurors, you are now going to be free to go to the jury room to deliberate. You'll take your notes with you. We'll give you a copy of the instructions that I've read at 3 different times today. You'll pick your foreperson and you will proceed to deliberate. We'll be in recess until the time we have a verdict. All rise for the jury. Be excused. You stand at the door right there. Let me swear my officer in. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made of them or to them, orally or otherwise, until a verdict is reached? So help you God. Thank you. Adjourned until we have a verdict.